Hello everyone, my name is Mark Halsey. I'm here with Fiona Halsey and we are Halsey Legal. The topic of this discussion is Asic notices issued in respect of the financial services industry, and I'd like to kick off by asking Fiona to tell us a little bit about what are Asic notices.
An Asic notice is a document issued by Asic which compels someone to do something. So it can compel you to provide documents.
Mm-hmm.
It could compel you to provide something else, like an actual object,
Mm-hmm.
or it can compel you to attend what they refer to as an examination, and what we refer to as a grilling.
What are the most common forms of Asic notices in the context of the financial services industry?
Yes. The notices are issued generally under either the Asic Act or the Corporations
Mm-hmm.
Act. And the notices which we see most commonly is a Section 19 notice
Mm-hmm.
under the Asic Act, and that's to attend and what they refer to as examination. It's an interview.
Mm-hmm.
Then there's a Section 30 under the Asic Act, which is to produce the books of a company or
Mm-hmm.
registered scheme,
Mm-hmm.
or under Section 33, which is to produce documents in a person's possession.
Yep.
And finally, there's the notice which is generally issued most frequently, which is a Section 912C, which is issued under the Corporations Act, and that's to provide information to Asic.
How do these notices work together, or do they work together?
Yes, they do. In the context of an investigation, it's not unusual for Asic to issue quite a number of different notices at different times. Now, my experience is that they would probably start with a Section 912C notice,
Mm-hmm.
which allows them to collect information. And that information can be in a format that Asic sets out. And it's not uncommon, for example, for them to require perhaps documents, a list of information to be put in an Excel sheet.
Mm-hmm.
And that could be, for example, all of the clients who've invested in a particular product over a particular time period. Then once they've collected information under the 912C, then they will quite often move to perhaps a Section 30 or a Section 33 to obtain particular documents or as they say, books. And when I say that, that doesn't necessarily mean hard copy. That includes anything electronic as well.
Mm-hmm.
And then once they've done that, then quite often then they would move to a Section 19 without actually interviewing people so that they have collected a base of information and they can ask targeted questions. But it wouldn't be unusual to then have done Section 19 interviews. They might interview, for example, staff of the organisation under a Section 19, and the staff would say, oh, well, there's this document, there's, for example, some kind of register.
Mm-hmm.
And then they might issue a Section 30 or 33 notice in respect of getting particular information, a particular document.
Okay.
Yeah, so quite common that they can use different things and that they can flick back and forward between the different types of notices.
So notices over a period of time.
Yes, very commonly.
So what should you do if you're a financial services practitioner and you receive one of these notices?
Okay, so the first thing to do is to read the notice carefully,
Mm-hmm.
and to take particular notice of the time frame,
Mm-hmm.
because they are always set with a time frame, and that in the case of providing information or documents, that's a date by which it must be provided, to a particular location as well. So there's a requirement in respect of that, so you need to make sure you've got enough time to do that.
Mm-hmm.
Or you would have the examination set for a particular day and time. As soon as you have read that closely, then you should contact your financial services lawyer, because these are serious.
Mm-hmm.
And I've had circumstances where people have said to me that they feel that their initial poor quality response to the first notice set the tone for problems going forward and created a situation with a much bigger problem than should have been the case.
That's a good reason to actually involve a lawyer. Are there any other reasons?
Yes, because what a very significant aspect of it is that you're able to obtain legal professional privilege on your communications with the solicitor.
Mm-hmm.
So if you've got, because you can imagine, say you've got a notice and that asks you to provide information, okay, what you don't want to do is you don't want to create further communications which themselves might be subject to a later notice.
Mhm.
Whereas if you obtain those and it satisfies the other criteria for legal professional privilege, you've got protection over those communications, which means you can be much franker in your discussions with your lawyer, with the knowledge that you'll be able to protect those communications, and that's very helpful.
That's given us a bit of an idea of what you're getting at with legal professional privilege. Is there probably more detail you can give us about what this legal professional privilege is?
Yes, and we've done a separate video on that. So that's the link to that's on our website, and that's probably helpful to people because it's got general application.
Okay. So how does ASIC issue a notice?
So they may issue a notice whereby they send it to you, and they effectively provide it to you in that way in advance. But there can be circumstances where ASIC can literally issue a notice on the spot. So, for example, if you're in a Section 19 examination, ASIC can.
This is the interview you're talking about.
Yes, exactly.
Okay.
Thank you. They've got a pre-populated form, and they can just fill out that form and say, we want the breach register
On the spot.
Yeah, exactly.
Okay.
And in some circumstances, people will have gone to the Section 19 examination and have the document with them. In other circumstances, they might have to locate it from another source. But yes, they can do it on the spot, which can be a bit confronting.
Can indeed. Now, with the actual notices, you're saying that they come with due dates or expiring dates or whatever. How seriously do you take those dates?
Oh, you should take them very seriously. The penalties for not responding to notices are substantial. Now, I wouldn't expect these to, if you missed a date and you had been in contact with ASIC and you were sick, something like that, you would seem unlikely to have this. But potentially, in a circumstance where you do not comply with a notice, there are some fairly substantial penalties. So, in the case of a company, there's a fine which is in excess of $500,000.
Right.
In respect of a person, there's a fine which is in excess of $50,000 and potentially 2 years imprisonment.
Yep.
And then finally, if you are a company and you're not complying with an ASIC notice, you risk your AFSL.
Right.
And if you're an individual, you're at risk of a banning order.
Right.
Because it is a law, it's a financial services law that it's a notice that you must comply with.
Sure.
And one of the criteria for banning is failure to comply with the financial services law.
Yeah, so these are the penalties for non-compliance in general, and because I raised the issue of the time frame, but this is...
That's right.
Yeah.
Exactly.
Okay.
You can sometimes get an extension from ASIC.
Yes.
So, but it's best not to leave that till the death knell.
Yep.
It's best to get onto that pretty straight away.
Which is reinforcing your idea, read the time frame, see if you can comply within the appropriate time frame. That's all been very, very helpful, Fiona. Thank you very much for that. And
I think that's it's a helpful thing because when a notice suddenly arrives, people are often and rightly so concerned. So that now one thing I will say is that this video does not constitute legal advice for any particular person.
Yep.
This is a discussion. We hope you find it helpful, but you should obtain your own legal advice before you act or refrain from acting. Thank you to everyone.
yeah, thank you.